Today, I'm doing another quiz. This one is on California's political and election laws, and in order to test some basic knowledge about these laws in the state of California. So, question one is like federal judges, California appellate court justices serve lifetime appointments. That's false. California judges do not serve lifetime appointments. They're ultimately subject to voter approval through the use of a retention election every 12 years. Question two, trial court and appellate court judges in the state are all appointed by the governor and then subject to confirmation by the JNE, we call it the Jenny Commission. That's actually false. Trial court judges are not subject to confirmation by the Jenny Commission, but appellate court justices are. Question three, in California, the two candidates who proceed to the November general election are the two candidates with the most votes at the primary. That, of course, is true because California uses a top two primary system now. Question four, California legislators are allowed a maximum of 14 years of service in either house of the legislature or a combination of the two houses. That's false. The total number of years to be served is now 12. Under the prior term limit law, it was 14, 8 in the Senate, and 6 in the Assembly. Question five, a legislator can sit out two election cycles and then the term limits law begins anew. That's false. The 12 years is a lifetime limitation. Question six, in California, corporate contributions to campaigns can be made. However, at the federal level, they are prohibited. And that's true. Corporate campaign contributions are permissible under California state law, but not federal law. Question seven, a business can make political action committee or PAC campaign contributions that combines individual contributions into the PAC at both the federal as well as the state levels. That's true. This is actually required at the federal level, but can be used at the state level as well. Question eight, some local jurisdictions in California use ranked choice voting. That's true. For example, the city of Oakland uses ranked choice voting to elect its mayor. Question nine, some local governments utilize a multi-winner election in which multiple candidates can be elected to the same office, such as a city council. That's true. This is used in a number of jurisdictions throughout the state of California. Question 10. The Independent Citizens Redistricting Commission draws district lines for congressional, state legislative, and county supervisorial districts. That is false. The commission draws lines for members of Congress, the state Senate, the state Assembly, and the State Board of Equalization. Question 11. All 9 statewide constitutional officers are elected on a partisan basis. And that's false. One of them, the Superintendent of Public Instruction, runs on a non-partisan basis. Question 12. All local offices are elected on a partisan basis. That's false. It is nonpartisan pursuant to the state constitution. Question 13. All lobbying disclosure forms are filed on a quarterly basis. That is false. Most are due, in fact, each quarter, but Form 602, the lobbying authorization, is filed upon a lobbying firm being hired by a lobbyist employer. Question 14. The legislature can disqualify electors who are mentally incompetent or who are serving a state or federal prison term for the conviction of a felony. That's true. This is permitted by the state constitution. Question 15. An elector who is disqualified from voting while serving a state or federal prison term is required to have their right to vote restored upon the completion of their prison term. That's true. This is actually a constitutional requirement in California. Question 16, voting is required to be secret. That's true. Under Section 7 of Article 2 of the California Constitution. Question 17, the Secretary of State is the chief elections officer for the state and is charged with administering the elections code. This is true, and it's actually found in the provisions of the government code. Question 18, the Secretary of State may send election information to voters electronically. That's true. This is found under the government code. Question 19, the Political Reform Act requires the Fair Political Practices Commission to regulate campaign finance laws, conflicts of interest for local and state public officials, lobbying registration and reporting, political mass mailings, gift laws, legislative documents, and finally the state archives. And that's false. The first 5 are specified in the government code, but the other 2, which again is legislative documents and state archives, are not found in the PRA and not assigned to the FPPC. Question 20, although the governor with 2 appointees to the FPPC, Attorney General, Secretary of State, and Controller each appoint 1 member of the FPPC, only the governor can remove any of the 5 commissioners. That's false. The members of the FPPC may be removed by the governor, but it requires concurrence of the Senate. And also it has to be for substantial neglect of duty, gross misconduct in office, inability to discharge the powers and duties of the office, or a violation of certain specified sections of the law. Question 21, ballot selfies are prohibited under California law because voting is secret. That's actually false now. California enacted AB 1494 in the 2016 session, which had repealed a 125-year-old law here in the state that barred voters from showing people their marked ballots. The 2016 legislation specifies that a voter may voluntarily disclose how he or she voted if that voluntary act does not violate any other law. Question 22, California has a voter bill of rights. That's true, found in Elections Code section 2300. And finally, question 23, there are spending limits for state Senate and state assembly races. And that's true. To accept these spending limits, candidates running for state Senate or state assembly must file what's called a candidate statement of intention. It's Form 501, and they file it with the Secretary of State and the Political Reform Division, indicating that those candidates intend to abide by the spending limits prior to submitting an actual candidate statement for election.